So I know people are still walking in, and I'm sure that at the end of this already long day, you needed your coffee break. But we're going to get started with our last panel for today, which I think is another very interesting one that follows nicely from what we've had before. You know, I remember at the very beginning of this afternoon, Joost mentioning the change in the name of the conference to focus not just on the WTO, but also on global economic regulation. And I think he mentioned something about not yet giving up on the WTO. And I think what he was referring to in part was our panel now, which will be all about economic regulation and how that's happening unilaterally in many cases, extraterritorially in many cases, and some of the questions about what does that mean, how do we deal with that, you know, should there be structures on top of that, etc. Then we heard Richard Baldwin talk in a great keynote speech, I thought, about globalization and how globalization is not just about goods crossing borders, but also about things like services and, of course, about people and humans crossing borders and interacting. Yet another area where I think economic regulation is critical. So with that said, you know, as the WTO is sort of losing in many people's minds a little bit of its centrality, whether we like it or not, global trade and global economic interaction and regulation, of course, haven't stopped. What has changed a little bit is that we're now often not talking about it purely in the sense of, you know, is this going to be a multilateral form of regulation or a bilateral or regional one? But in many instances, it ends up being unilateral and extraterritorial. So that's what we'll focus on, and we have a great group of speakers here. I won't introduce them in detail because you all have this here, but just so you know the order here. So we have Pierre-Hugues Verdier next to me here, who is a professor of law and director of the graduate legal studies at the University of Virginia Law School. Then next to him we have Chris Brummer, one of the organizers, of course, here today and at Georgetown University. Then next to him is Martina Laudront, policy assistant to the Director General for Trade at the European Commission, and among other things, very closely involved in formulating the EU's external trade strategy. Then we have Professor Heng Wang, co-director of the University of New South Wales's China International Business and Economic Law Initiative, and focuses very much on the Belt and Road Initiative, among other things. And then finally, we have Xi Jinping, who is a professor of law at National Tsinghua University and associate dean of that university's College of Technology Management as well. So what we thought we'd do is we would do some relatively brief introduction by each of the speakers on their areas, and then we'll pretty quickly turn to questions from the room. Pierre, let me start with you. You just published a paper on the new financial extraterritoriality. Can you tell us a bit about what we're seeing these days in the financial services sector? What kinds of unilateral and extraterritorial regulatory behavior, and how that affects things like coordination between governments and between countries and the companies acting in that space? Thanks.
Thank you, and thank you again for the invitation. So the paper that you just mentioned is part of a larger project that I've been conducting in the past few years. This is the first paper that comes out about it, and I'm also working on a book. And the book is tentatively titled Global Banks on Trial. And this is a somewhat ironic title because, of course, none of the global banks have actually gone to trial. All of these criminal actions that I'm writing on have been resolved through some sort of negotiated settlement with the U.S. Department of Justice and other regulators in the United States, sometimes in collaboration with their counterparts abroad. But nevertheless, my point is that this is a very significant development, so I'm trying to look at it systematically and try to think about its implications for global economic governance. So I'll give a quick introduction to the phenomenon that I'm talking about. It is maybe not something that people in the trade space have focused as much on. And then I'll go on to give a few thoughts about these implications. So what I'm talking about here are a series of criminal cases initiated by the U.S. Department of Justice, settled, as I indicated, through instruments like non-prosecution agreements, deferred prosecution agreements, and in some cases, negotiated guilty pleas in which banks have accepted criminal responsibility. They have targeted many of the world's largest banks, and for purposes of this project, I looked at those banks that have been on what's called the GSIB list, the list of globally systemically significant banks that has been compiled on a regular basis for regulatory purposes by the Financial Stability Board. And I've looked primarily at the 2008-2016 time period, although this is an enforcement campaign that is still active and there are still some of these resolutions going on a fairly regular basis. In 2018, Société Générale paid $860 billion for LIBOR manipulation, and as recently as this April, UniCredit, the largest bank in Italy, paid $1.3 billion with respect to sanctions evasion with respect to Iran. So looking at the project more broadly, what I've been looking at are three sectors in which this enforcement campaign has been particularly active. Tax evasion is one of them, basically the United States going after banks that facilitated tax evasion by US taxpayers. The most spectacular case was UBS, as I'm sure is very familiar to those of you who are from Switzerland. In 2009, UBS agreed to pay $780 million to the US government, and eventually that led to an agreement to disclose more than 14,000 names of US taxpayers, which was the first major, vast breach of Swiss bank secrecy in, one might say, in history. And this was followed in 2014 by a settlement with Credit Suisse for $2.6 billion. The second area is benchmark manipulation, so banks involved in attempts to manipulate not only LIBOR, which is the world's most important, or was at least the world's most important interest rate benchmark, but also other important benchmarks having to do with foreign exchange, trading. Here, once again, the first and perhaps most symbolic case was the Barclays case that came out in 2012. Barclays only agreed to pay about $450 million, but it led to a major scandal through which most of the leadership, the CEO and the chairman, had to step down. And in 2015, Barclays, RBS, and UBS entered guilty pleas with the United States with respect to foreign exchange manipulation. And the third major area is sanctions violations, something that still is very much on the agenda today. And some of the most important and most symbolic actions have been HSBC in 2012 paid $2.5 billion with respect to a number of money laundering failures and sanctions evasion practices. And of course, BNP Paribas in 2014 paid $9 billion to the US government with respect to sanctions evasion with respect to Iran, Libya, and a number of other, the Sudan, and a number of other jurisdictions. And this was at the time the largest criminal fine ever paid in history. It was surpassed by the BP oil spill settlement shortly afterwards. But my point here is that these cases are very high-profile cases. They've made headlines around the world. In total, just in these three areas, the largest banks in the world have paid something like $32 billion in settlements with the US government during that period between 2008 and 2016. And that's counting only the foreign banks, so the foreign-based GSIBs. I'm not counting the other large fines paid by US banks. And it also excludes the mortgage settlements, which were not criminal in nature and were mostly targeted at practices that took place in the United States itself, so they're not as extraterritorial in orientation, but nevertheless they're important too. They amounted, in fact, to more than $100 billion in total. But because I want to focus on the international implications of this, and especially the implications for banks based in foreign countries, then I've decided to exclude those. So if you look at the paper actually that Naboth cited, the paper that has come out at this point focuses mostly on U.S. domestic law aspects of this. Is this enforcement campaign, the use of criminal law that's made by U.S. prosecutors, is that compatible with restrictions on U.S. personal jurisdiction over foreign companies and banks? Is that consistent with what's called the presumption against extraterritorial application of laws? And I note that there are some important legal issues from a U.S. standpoint with respect to that. But what I want to explore in the next few minutes and in the book are the implications more broadly for global economic governance and U.S. unilateralism more specifically. And I want to make 3 brief points on that. The first important implication, or the first important point, has to do with the actors that are involved in this, and more specifically the role of prosecutors. Now, if you are familiar with the regulation of international banks, this has traditionally been an area that has been spearheaded by national regulatory agencies, so specialized regulatory agencies and supervisors, mostly in the bank's home state, with some degree of international cooperation that tends to be organized around standard-setting bodies and informal networks of regulators through a non-binding framework. And I'm thinking here, of course, about institutions like the Basel Committee on Banking Supervision. So this has been traditionally the world in which these banks have operated at the international level. And this is a world in which the normal means of imposing regulation on global banks has been through supervisory tools. So supervisors go into bank, and through a cooperative relationship mostly, they conduct examinations, they look for failures that can be corrected through a collaborative process, and they tend to resort to their enforcement tools, which do exist, as a last resort. And what we see with the rise of what I call the new financial extraterritoriality is a shift to a very different and much more coercive approach that's driven not by the traditional regulators, but by prosecutors that tend to come to this with a very different perspective. Now, what does that mean? It means that, first of all, there's a shift from the traditional approach to criminal prosecutions in that space, which was that in some cases, supervisors would decide to escalate, to cross the street, to basically take some bad behavior that they had detected through their examination process to the Department of Justice because they thought it warranted criminal prosecution, which only DOJ can bring. But what we've seen in some of these cases is DOJ acting as more or less an independent actor in that space. These cases are not initiated because they've been detected by the regulatory agencies. They're initiated independently. The UBS case is perhaps the most famous example, where the whistleblower from UBS, Bradley Birkenfeld, just went directly to DOJ to try to negotiate leniency, and that resulted in the case being brought. But there are many other examples where basically the case arose out of investigations completely outside of the normal regulatory and supervision framework. These actions also often revealed some important failures of the regulatory framework, cases in which practices had persisted for a long time that were illegal or abusive, and for which the supervisory agencies had failed to take effective action. And perhaps the most spectacular example of that was the LIBOR scandal, in which after the Barclays settlement in 2012, it became very clear through parliamentary investigations in the United States and in Britain that the Bank of England, the FSA, and to some extent parts of the Fed in the United States were aware of the fact that there were at least some significant clues that LIBOR manipulation was going on, but decided essentially to defer to the British Bankers Association, the association that ran and published LIBOR to conduct some internal reforms that were fairly minimal. And it's only several years later, because of the DOJ and CFTC investigation, that things really that the scandal really came out and led to very substantial, much deeper reforms to the LIBOR setting process than had been done before. And the prosecutors also bring very different tools to this space. They bring investigatory capabilities that are not really in the toolbox of traditional supervision agencies. And one of the quips that someone made in this context, one of the CFTC investigators, was that, well, people lie to us all the time, the regulators. But when there's an FBI agent in the room, things are much different. And I think that's reveals something important about these investigations being conducted the way they now are, is that they raise a whole different level of risk for banks and bank employees, and they also raise much higher possible penalties. And finally, they raise the ability, or they rely or result in US prosecutors being able to impose, as part of these settlements, very extensive compliance obligations that affect banks worldwide. And this is quite significant. An example is HSBC, which is part of its settlement, and this was not very widely noticed because they agreed to pay a ton of money and it was a big scandal. But also, if you look at the settlement, HSBC agrees to follow US sanctions policy in its banking operations worldwide, even in places where it is not required by US law. So it is not formally required by US law in the absence of this settlement. So this has been a tool for the United States to project its regulatory and sanctions policy by essentially enlisting the global banks as implementers of that. I have two other points that I'm going to make much more quickly. The second point is that if you look at these actions, it becomes quite clear that the ability of the United States to do this, to credibly threaten these banks with sanctions and be confident of the fact that they will agree to comply with that and that their home state government are not going to protest too much, is because the United States controls the central hubs, the central nodes, if you will, of the international financial infrastructure. And this is much different from the way people normally think of market power in the trade and regulatory space more generally, where the way to think of that, I think, traditionally is, well, the United States is one of the world's biggest markets, and therefore it has the ability to some extent to extend its regulatory framework by setting conditions to market access and threatening loss of market access to people or organizations that don't follow them. Well, this is similar, but it is somewhat different in the sense that those global banks, the G-SIBs, they need access to US dollar payments. They need access to securities and derivatives clearing in the United States. They need access to exchanges and other trading platforms in the US in order to conduct their business. So if the US excludes them, it's not just excluding them from US business, it's excluding them from their ability to conduct their basic functions worldwide. And so the threat is an extremely serious one, and you see that time and time again in these different cases. BNP was perhaps the most salient example. BNP had and still has a huge business acting as a correspondent bank for many banks around the world to process their US dollar payments through its branch in the United States. It was threatened as part of the settlement that was being negotiated with a suspension of its ability to do that, and that was by far the most serious threat it was facing. And in fact, it found it much preferable to pay $9 billion in fines than to have this ability be suspended in a significant way. And the third point is, well, this is clearly an initiative that's mostly unilateral on the part of the United States. So how does this relate to this question of unilateralism more generally? In terms of the impact of these prosecutions, I would argue that it really depends. The impacts are somewhat different in different areas. Sometimes you could say that this is a self-interested tool, if you will, for the United States to leverage these banks and these prosecutions to advance its foreign policy interests in areas where its partners would not necessarily agree. And the most clear example of that is sanctions. And you see that today with the difficulties that European banks have, despite the policy of Europe to continue to comply with the agreement with Iran, the difficulty that these banks have, or that Europe has, to convince the banks to start doing business with Iran. Again, that's proven more or less impossible because of how serious the threat of enforcement is on the US side. And that's not just due to secondary sanctions, but it's due to this threat of losing the ability of executing these trades in the United States. Now, in these areas, this obviously opens up a risk of fragmentation because it creates incentives for partners like Europe and other countries around the world like Russia and China to think about how they can decouple themselves from these elements of centralized international financial infrastructure. And therefore, this is potentially, this kind of use of this power is a risk to the stability or to the longevity of the integrated system of international finance that's been developed in the past 20 or 30 years. But in other areas like benchmark regulation, I would argue that these unilateral approach has been very beneficial. These benchmarks arguably constitute global public goods. They are valuable to actors around the world. They were not being adequately regulated by the home state or the state that had taken primary responsibility in principle to look over the LIBOR setting process. And therefore, the United States enforcement campaign has contributed, arguably, to preserving or protecting their value as a public good that's used by actors around the world. And even in some cases, the US unilateral enforcement actions can lead to multilateralism, and maybe we'll have a chance to talk a little bit about that later, but I think the tax evasion case is a good example of that, where there has been very significant development of multilateral approaches to tax information exchange, in large part in response to the US enforcement actions. So I do think it's sort of a mixed bag in terms of its implications, and it makes this field quite interesting.
Thank you very much, Pierre-Hugues, and I think that was a great sort of introduction to this whole concept of extraterritoriality and you know, a unilateral application of rules and what that means in different sectors. Chris, you are looking at this, of course, also, you know, I think primarily from a US lens, but also more globally, but with a heavy focus on FinTech. How does that compare here, and you know, given that that's an area where we see some other countries, of course, also being very active, how do we deal with that?
Great, thanks so much. I know when you're on a panel either before lunch or on the last of the day, you kind of want to get to the point, so I'll make my comments very brief, but the interest in FinTech comes from a book that actually had global origins that are a global interest that I'd written called minilateralism. And the idea of minilateralism, it's actually a very old term, not just from its political science connotations and uses. I wanted to deploy that term in a more modern sense of thinking about the transition from the multilateral system to something that we call minilateralism, if I misspoke. The theory of the book was that traditional multilateralism had three pegs. The first peg was an aspiration for universalism. The second peg was a preference and a reliance on formal international legal obligations. And then the third was an anchoring in the US dollar. And the theory of the book was that each of those three pegs was undergoing a considerable amount of stress. That on the one hand, you had a preference and a move towards alliances that we'll hear about very shortly. Secondly, there was a reliance, particularly in the conduct of international financial diplomacy, on non-binding international obligations, in part to keep up with fast-changing, highly mobile issue areas, not just objects of regulation. And then third, the theory was that with the rise of China in particular and the rise of the renminbi and the creation of various offshore financial centers, that over time, there were at least the building blocks being presented to create, at a minimum, a series of potential alternatives, obviously including the euro, with the caveat that the euro could sort of get its act together. At that point in time, I was writing about the Eurozone crisis. Now, several years later, I sort of began to look at that theory, and I kind of felt that I was good for two of the three. Certainly, you see a rise in alliances of all sorts and of regional agreements. Secondly, you see a proliferation of soft law agreements, including, I would argue, a softening of the WTO itself through everything from side agreements in international trade negotiations to a weakening of some of the doctrine and presumptions that were sustaining the WTO. And then for the US dollar, that's one of the more interesting phenomena, which is that you see sort of the renminbi internationalization in some ways slowing, even as the country tries to double down on expanding its regional trade footprint. But you did get a new kind of potential challenge to the US dollar in the form of cryptocurrencies. You know, I had not anticipated at that point in time that there would be an attempt to go not so much to the future, but a little bit to the past, and to effectively create private communities or alliances of the willing to invest their time and belief systems into a new technological or into a new kind of payment instrument that was ultimately backed by and supported by what would now be known as a distributed ledger. The other thing that I've found to be quite interesting is that many of the ways in which this sort of new alternative payment systems and new alternative currencies are being created itself is relying on new kinds of economic statecraft. Certain kinds of non-binding MOUs are helping to facilitate cross-border cooperation on FinTech development more generally. It's very interesting that regulators would sign agreements and MOUs that really have a distinct market access underpinning to them. And the rise of FinTech or globotics is starting to transform the way in which international economic diplomacy is being practiced, because FinTech itself is starting to rise to the top of the agenda of a variety of financial and monetary to-do lists. From the standpoint of, obviously, central bank digital currencies and the exploration of ways to increase financial inclusion through central bank digital currencies, to the exploration of new kinds of asset classes through something called initial coin offerings. We can talk about all that stuff, but that's it, and we can explore that issue. Are those issues, any of those issues? I got cards. We can explore any of them.
Thank you, Chris. And given how short you actually kept your remarks, maybe I can ask you one sort of related question that I think you might be able to address as well. So I know you've done a lot of work in the FinTech space generally, and I think that's an area where, you know, as we speak, we see regulatory developments in a number of countries around the world, right? And because it's an area where, you know, the US obviously has a number of the big players and the innovators, but then the same is true for China. We see Europe regulating in that space increasingly, and we see other countries doing so. How do we deal with that in the FinTech space?
So number one, there's a question. There were a range of questions that were brought up earlier on this question of data, for example. And I've talked to a lot of financial regulators. You know, the trade folks are trying to figure out, well, what is the property value, in essence, of data? Like, how do you treat it? Well, financial regulators are doing the same, and a very good colleague of mine from the European Commission is saying, we're no longer financial regulators, we are data regulators, because you're trying to think through what kind of information is ultimately going to be transmitted across borders. That information is being tested in terms of its veracity. the kinds of potential systemic risk that information can itself catalyze, depending on how it's being internalized by different kinds of market participants. And then obviously the fact that financial technology is geared towards disintermediating these legacy financial market participants means that you have to come up with a new regulatory paradigm for dealing with certain kinds of instruments that fall in the interstices, in the gaps of your existing, New Deal 1930s regulatory frameworks. And I think that that's a challenge. Joost began with, being very, very sad about the future of the International Trading Organization, particularly for some of the students. But the great thing about being a student is that you're on the ground floor for all these changes, and therefore it levels any kind of comparative advantage that, folks may have had who are familiar with legacy regimes, right? Because you're building a new thing from scratch. And I think that financial regulators are doing very much the same thing and trying to think through, well, and market participants, what is a blockchain? What is a distributed ledger? How does that fit into how and what we define to be a security or a commodity? Same thing in trade, in which you're trying to figure out, well, what is, is our blockchain technologies covered by the GATS or not?
Thank you, Chris. And I think that's a nice segue also to Martina, actually. So Martina, I think we were hoping that you could tell us a little bit about what the EU is doing in terms of, both unilateral action and how that then might relate to multilateral action. I think there's sort of this tendency to think, particularly right now, to think about the U.S. as the big unilateral actor, right? There are tariffs in place that are unilaterally determined. The Trump administration is acting on its own in many areas. But then there are other people who will say, well, actually, the EU is acting unilaterally in some areas as well, particularly in some regulatory areas like privacy, digital taxation, competition policy. How do you see that?
Thank you. First of all, I do have to say that I speak in my personal capacity. I will share my own biased views and not those of my institution. I want to make 3 points on this topic. First point is that the EU is genetically predisposed towards a multilateral rule-based system. So it has used this type of extraterritorial regulation less frequently and also more cautiously. And third point, this might change in the future. On the first point, on the one hand, the EU has been committed to multilateralism simply because we saw the benefits, we saw the stability it has provided over the decades and reduced tension. But the commitment is also in some sense in our DNA because the EU itself is a rule-based union of states. It's not a unitary state. So we do this kind of international cooperation based on rules within the EU every day across a multitude of topics and areas. We negotiate, we make compromises, so it's natural for us to do that also at the global level. We feel quite comfortable about that. At the same time also, our own structure is not always very, doesn't always make it very easy for the EU to leverage our economic weight to project our interests in a more sort of hegemonic way, to put it that way. So this leads to the second point that helps explain why extraterritorial legislation in the EU is less common than in the US. We heard a number of examples from the US. And when such measures are taken, we approach them more cautiously. Now, what I mean by that is there has to be very good and legitimate reasons for that. Also, there has to be there's always a nexus to our own market. So the concern is about what happens and the effects in our own market. And thirdly, multilateralism, or at least a negotiated solution, would have been explored first. And if that fails, then we look at other options. And final, very important point, it's the compatibility with the WTO, so with our international obligations. And that's always a very important consideration. And I would argue that these features are present even in those EU extraterritorial measures that are quite controversial. So the ones that have been mentioned. So, and we can look at some of those examples. For example, competition. The rules or the extraterritoriality of the rules is not so controversial. It's how those rules are enforced. And the Commission, as the EU competition authority, has been accused of applying them with perhaps too much zeal, or particularly against, for example, the US digital giants like Google or Apple. But of course, you also have to look at the structure of that sector. There is no big European digital company. So though where there are concerns about abuse of dominant position, it's of course with these big companies, which happen to be mainly American, or some of them are Chinese. And in fact, you will see growing concerns about their competitive behavior of these American companies also on the American side. So it's not just a European concern. Also, when it comes to EU competition rules, I mean, there is an opportunity to challenge those in the European Court. Our rules have provisions on proportionality, on non-discrimination, on procedural fairness. What is true is that we don't have a multilateral framework that would, in a way, discipline the application of competition laws, and that would, for example, provide also then a way to resolve disputes. But again, the EU has actually tried that in the past. So we have advocated some WTO principles on competition. Unfortunately, that was not successful. So the other example, data protection, of course, this is very much in the spotlight. And again, our rules have been characterized either as protectionism or as an attempt to, impose our societal choice on everyone else, so to create a global standard. And again, I think this view ignores a few points at least. Yes, there is an extraterritorial element, but our rules are only there to protect personal data of individuals in the EU. That's the first point. In the EU, privacy is a fundamental right, so the safeguards to protect it have to be strong. And if you look at international standards, they are insufficient from that perspective. So this is why our rules have gone further. And the extraterritorial scope is necessary if you want effectively to protect data in a context where it's very easy to move data across borders. So protection has to, in a way, travel with the data. Also, in terms of how our rules impact, the choices that other countries have, it's true that the best way to facilitate or to enable free flow of data from the EU is for another country to put in place equivalent legislation, but it's not the only way. Companies do have other mechanisms to legally transfer data, even if the legislation in a country is not equivalent. And for example, in the case of US, we negotiated the privacy shield arrangement, so it also shows a certain pragmatism on the part of the EU. Moreover, these rules are not really preventing the EU to be very ambitious in the ongoing e-commerce negotiations now in the WTO. We're very active in tackling data localization requirements and facilitating the flow of data. The third example is a digital tax, for example, you mentioned at the beginning. Now, I mean, this is a tax on companies selling digital services in the EU, even if they're not established in the EU. I mean, the issue there is that these companies are generating large revenues and monetizing the data of the users in the EU, but they're not really paying, they're paying hardly any tax there. And it's a very pressing concern. Of course, it's also very controversial because at the end, this is about how you divide the rights to corporate taxation among countries, and particularly in a context where some have more of these digital companies and others have fewer. There is a multilateral process in the OECD to try to find a multilateral solution to this, but at a certain point, it just wasn't making a lot of progress. So this is when the Commission proposed that the EU moves ahead with a measure, its own measure. Now, at the EU level, actually, this text has never been adopted. You know that on taxation, we have a unanimity requirement, so all member states have to agree. But some individual member states are now going it alone. But the good effect of this has been, at least, we've seen that the possibility of the EU enacting a tax unilaterally seems to have injected some new momentum in the OSCE discussions, and we continue to be involved in that process. So that's how much I'm going to say in these examples. I would like to look a little bit into the future, but I look towards you whether you want me to do this now or leave that for the questions and answers.
Maybe we can leave that to the questions. Let me ask you one quick follow-up, actually, because I think one of the issues that one of the questions that sometimes comes up when people are talking about how the EU is using its regulatory power, right? Its sort of soft power in the regulatory space is, you know, is it actually sort of an active, intentional policy or strategy to try to apply regulation in a way and to try to almost sort of push regulation and regulatory preferences on other countries. So I guess my question in that respect is twofold. Is one, is that the case in your view? And two, whether it's the case or not, you know, is that something that is unique to the EU, or do we see other countries doing the same thing, but maybe in different sectors or in different spaces?
Well, I think in all these cases, the primary motivation is definitely there's a concern in our own market. There's, you know, whether it's, like I said, privacy, you know, protection of personal data, which is a big concern of EU citizens. It's competition, you know, in our own market. So I would say that's the primary driver. Of course, the EU also has an interest to project its interest globally. But I think, you know, we do this sort of differently. On one hand, like I said, we're kind of used to negotiating and making compromises. You know, we think that that's a good approach, and in the long term, more stable. We also have our own weaknesses, which don't allow us to just, you know, dump things on or impose things on others. But I mean, sometimes, you know, and again, if I go back to the example of data rules, because just this morning, you know, I read an article from Politico, which in Brussels everyone reads Politico now, how the EU is imposing a global standard on data privacy. You know, I think, you know, it certainly has, we certainly have an interest. It's good for us if others do the same. But I think that was really a motivation. The motivation was really about what do we do to protect what in the EU is a fundamental right. And some of the other countries have the same concerns. So they're not necessarily adopting, you know, stronger rules or looking at the EU as a sort of, because they feel that they have to, because we've done it and because, you know, they have no other choice. I think it's also a concern, and they may see the EU rules as a good model to, you know, partly mirror, to be inspired by. So I think we should be very careful to say, okay, you know, we're just imposing this and there's no choice. It's concern that others share, and they can, if they see a model that works, they have their own motivation to follow.
Okay, great. Thank you very much. You know, and kind of again, sort of segueing from that, you know, I think one of the things you're talking about is sort of that spread of regulatory approaches to other countries and the ways in which that happens. Sometimes naturally, sometimes just by collaboration, etc. Which I think is a great segue to hang to what you're going to talk about, which relates to what China is doing in the context of the Belt and Road Initiative, as well as, of course, some of the China trade issues that we're seeing and that everybody is talking about these days. So maybe I'll give the floor to you to talk a little bit about those two things.
Thank you, Nibos. And also I have to thank Chris and also Just for the invitation. Of course, I speak on a personal capacity as well. I think I look at China's approach more, China's practice to look at what is the future or the new order in the global governance. I think I will look at 3 aspects. The first one is what's the problem nowadays for global governance, more from China's perspective. And secondly, what are the approaches, particularly of China in this regard, which means the Belt and Road Initiative, the BRI. And finally, what are the future possible order would look like. I think now if we look at the crisis now we're facing either in the WTO or trade war and so on and so forth, I think we have to take into consideration that the core of these problems are probably the US-China tension. I think if we look at that from, if you look at China's practice like Belt and Road Initiative, look at trade war, if we look at WTO crisis, I think from a legal perspective, at least there are 2 major legal issues or problems. One, I think that the WTO rules are kind of out of date, and now people feel that they are not able to work to deal with current issue. And then you have to deal with how do you look at those relative independent issue like national security. States usually say that these are matters like Trump that we deal with that on a national security, so they should not be adjudicated by any third party. And another side of the story is that how do we address the rest of the interdependence? So that's what WTO has done in the past. How do we make sure the trade flow smoothly, and they have discipline towards that. Another issue I think is about how do we balance between predictability and certainty. We want rules to be predictable. The business can drive down the cost. Another side, we want to make sure how do we deal with dynamism and responsiveness. So that's a problem we're now, for example, facing by FinTech or data localization, all those kind of technology issues which deal with takes a lot of uncertainty. So these are the problems that I think the 2 major issues that's reflected in the lack of trust between US and China, or complex issue, and so on and so forth. But I think behind this issue is the difference between Beijing consensus as well as any new Washington consensus. So I would look like the second issue. What is the approach? Because the US-China have different approaches. Trump changed the Washington consensus. They're now being more America first, and also bilateralism. And another side, Beijing consensus has been promoted under BRI. So I will look at the BRI, China's approach towards that. It's based on a paper I published at GEO. First one about China's approach is how do we understand BRI? I think if we want to understand the BRI and its implication, we probably have to use a functional approach. So functional approach means that we look at what are the measures China has taken to realize the goal of the BRI, either international cooperation, which you can take from the China's joint communique of the BRI forum that mentioned about international cooperation is one of the aim, or to look at other measures which help another objective of BRI, like economic integration, or connectivity or sustainable development. And the second point I want to make is that BRI reflects a kind of hub and spoke. So China is being the hub. China has a lot of BRI documents, projects, and you look at like 2 aspects. One is software. The BRI software is like the mechanisms or agreements. So China has an unprecedented number of MOUs with other countries, and particularly nowadays with also international organizations like UN, and also recently with non-federal or non-central government of like in Victoria government, Australia, and so on and so forth. And also you look at the hub and spoke, also look at hardware. China's building the projects, the dam and the roads and so on and so forth. The third point is that China also take institutional mechanism, using United Nations to recognize the legitimacy of the BRI and to developing CICC, International Commercial Court of China, and to serve part of the disputes of the BRI. And a fourth point is about the rules. They use treaties, but more importantly, using soft law, the international MOUs, bilateral ones. And what does it mean? I think if you look at these 4 aspects, my observation is that it's what I call maximized flexibility. So China being selectively proactive in areas like dispute settlement, in area like trade and investment facilitation, which is good for BRI implementation and also not so sensitive. And China has been less active in area like social norms, and in that regard. And so the maximum flexibility refer both in rules but also in institutions. So try to be more efficient to deliver instead of wait to treaty. Then the final question here is that how is BRI sustainable? I think that China's maximum flexibility has two sides. The one side, you enable trial and error, so you can test the water. Another side is you still have a concern regarding predictability or consistency, as well as transparency. So BRI basically is moving. So it's a moving target, which deserves a lot of attention. And then I look at the third question, what's the future of the emerging order? I think I have 4 observations. One, I think, unfortunately, although I was in WTO before, WTO is close by, but the multinational disintegration happens. And also means that they are further invigorate or the rise of the regionalism. So regionalism is being rising. For example, BRI is likely to play a more important role, or for example, for China's perspective, kind of plan B if the trade agreement with the US does not work out in that regard. And second, I think WTO is likely to be marginalized or play a more limited role. The problem is that actually in the WTO has been, in the past maybe have a hegemony. The US would like to be very supportive of that, but now you see a lack of leadership in the WTO. Another side, if you look at it, rules, the unilateral measures put the WTO rules at risk. So all those kind of things means that there are a lot of, unfortunately, further marginalization of WTO unless they have strong political willingness. Third one is a trade war is likely to speed up the reshaping of the BRI to some extent. And the BRI is likely to have a more impact on global governance. The reason is that actually if the trade agreements has been made between US and China, which is unlikely, and China may be affected by the disciplines regarding the governance, good governance, and also the transparency and other aspects of BRI. Or if the trade agreements will not be reached, which is highly probable, between US and China, the BRI will go down the track that China won't promote the BRI further. As you see, Italy jump on board and mention other G7 countries also be interested in that. And UK is also quite interested in that regard. And China also won't like to respond to the concerns some of them faced. I think international legitimacy, for example, is one of the areas that deserves attention on that. And eventually, because the BRI does not really have a comparable regional counterpart, the CPTPP, for example, is not as big, as powerful as the TPP, with the US withdrawal from that. RCEP, it's hard to be a replacement of that. Even RC itself is difficult to be united or be very efficient. So the BRI is likely to be more important in that regard, in the impact. Finally, I think we are likely to go to a world of disorder, which is a pretty bad idea. So that means that actually, because nowadays Trump and China's counterpart has been seeing the difficulties in reaching agreements, I think this gives incentive or to pitch the disputes a kind of ideological conflict, because in this way it's easy to push the burden to other side. And then you see that actually the major economies, like US and China in particular, is like to set a future pathway. But also, I think everyone will have a say on that. Because for other countries or economies, if they're united to support a rule-based system, it's likely to have a kind of balance in that regard. So I think that everyone needs to be participating in the future of one, because everyone will be affected. We don't want jungle rules. We don't like world disorder. So that's the reason why we're here, for example. I think we're likely to miss opportunity or upgrade the rules, like to solve the problems, because US China are likely to reach agreements. And we have high demands but less rules, less tools. So it's no longer a spaghetti bowl. I think the future looks like a mixed stew. Sorry for that. Thank you.
Thank you very much. And I think we'll get back to the mixed stew later on. Xinyi, we'll end with you, and by doing so, I think we're moving back a little bit to a particular sector, right? Because you focus very much on digital economy issues, but then also we're moving back, I think, a little bit in your comments. We'll talk a little bit more again about the role of the WTO. So getting a little bit closer to home, I think, for a lot of the people in the room here. So the floor is yours.
I hope so. Thank you. Following the comments made by other panelists, allow me to look at the new trend in global economic regulation from a different angle. I will focus on the question as to whether the regulators' emerging discretionary practice, in particular in the innovation sectors, are permissible under the WTO law. Can any mechanisms under the WTO or other free trade agreement serve as an effective tool to prevent arbitrary administration, to prevent discretionary abuse, or to prevent regulatory overreaching? More importantly, how to promote regulatory cooperation. As a starting point, I think it's worth reiterating that it has been a challenging task for the sectoral regulator to respond promptly to the pace of the rapid and constant changes in market. Given the technological evolution, even not the revolution, very often the regulators are confronted with new business practice that do not fit comfortably within the existing legal framework. For example, is Uber a taxi service or not? Should the city authority of Geneva regulate, enforce the existing taxi regulation on Uber? Is Airbnb a hotel service supplier or not? Should Airbnb host get a hotel permit? Is Netflix a television service or not? How to impose the content quota on Netflix? Is Skype a telephone operator or not? How can we impose the universal service fee on Skype? So what I'm trying to stress is that from my practice experience working for the government, indeed it is necessary for the telecom operator to adopt a more dynamic approach, to operate in a more reactive manner, and to implement policies that can adjust to the changes in market. However, incorporating such flexibility into the decision-making process can open up a wide range of possible actions. So let me give you a more concrete example here that in most of the jurisdictions, the telecom law does not provide a clear-cut guidance as to whether the chat applications such as WhatsApp or the voice calling services such as Skype fall within the definitions of telecommunications. In other words, in many jurisdictions, the telecom law only provides a broadly formulated guidance, and under which the telecom regulator is entitled to exercise a great deal of judgment to interpret the law, to apply the law, and to classify the new service. Apparently, law and regulation in some sectors is taking the form of vague language, which requires the regulator to engage in interpretation. In this context, Article 10.3a of the GATT and Article 6 of the GATT can be seen as an obligation that impose a fundamental standard based on due process and good governance, right? So as you are familiar, Article 6 of the GATT, which is modeled after Article 10.3a of the GATT, require that domestic regulations affecting trading services should be administered by in a transparent, reasonable, objective, and impartial manner. However, in my view, one particularly complicated aspect of Article 6 of the GATT is the reference to the measure of general application. Because typically, an agency decision addressed to a specific individual or company or entity fall outside the scope of Article 6 of the GATT. in the EC poetry, the panel clarified that the license issued to a specific company should not be considered as a measure of general application. And last year in the EU, I think, energy package case, the panel repeatedly pointed out that the misapplication of a regulation in a single case cannot constitute a violation of Article 10 of the GATT unless there's evidence showing that the same misapplication is arising or will arise in a widespread manner to the extent that it could establish some sort of criteria in future cases. So go back to the telecom law example I just mentioned. I would say agency decisions regarding the classification of WhatsApp or Skype may not be covered by Article 6 of the GATT. So the provision seems to be not an effective tool to prevent abuse. So here I would like to add that arbitrary qualification requirement or unclear licensing procedures may limit the trade, just as tariffs, quota, or other protectionist measures do, right? And excessive standards and requirements can seriously prevent service suppliers, to compete from, to compete on a level playing field. And in addition, as the number of countries involved in the supply chain increased, I would say that the difference in regulations, requirements, is becoming more significant as a trade barrier because the traders are confronted with significant challenge when they try to comply with the diverse behind-the-border measures. So the lack of consistency in finance, in telecom, in any sectors among countries is costly and burdensome, simply because the traders, they need to meet different standards, they need to seek multiple approvals. And in this regard, GATT Article 6 contains too few real obligations. I mean, arguably, Article 6 of GATT remain provisional, right? So in this regard, I would say further disciplines should be politically popular because such discipline can ensure that domestic regulation will not render the market access commitment meaningless. And having said that, recent progress in the FTAs, namely the good regulatory, regulatory coherence chapter of the CPTPP, regulatory coherent cooperation chapter under the CETA, and the good regulatory practice chapter of the new NAFTA, the USMCA, can serve as a useful reference for future trade negotiations on how to promote regulatory cooperation. However, in my view, that there are some problems. For example, let's take TPP as an example. In the TPP, each party has the right to decide to what extent its domestic regulation will be subject to the chapter. In other words, the scope of the regulations that are governed by the chapter is somehow flexible. So it lacks a legally binding commitment and therefore is uncertain. In addition, there's a non-application of dispute settlement clause. So no disciplines are imposed for non-compliance. So I would say the TPP regulatory coherence chapter is a soft regime and is based on soft law approach. So to respond to the overarching question of this panel as framed by our organizer and moderator, are we moving away from a traditional, treaty based on multilateral rules toward a more flexible cooperation based on a pragmatic way? I would say, after all, those new disciplines, the regulatory obligations, were politically motivated by the desire to leave plenty of rooms for future interpretation. as to how far the regulators are required to apply those disciplines into the decision-making process. So it remains to be seen how those new disciplines, obligations can, in the long run, promote international cooperation on economic regulation. I will stop here. Yeah.
Great, thank you very much. I already see some of our panelists ready to react to that, and let me do that actually. Let me give you some time to do that before we turn to questions from the room, because I think one of the interesting themes that you've touched on now is this whole the overarching question, right? The overarching question. So in this time period where we are seeing regulation in lots of areas, often extraterritorially, whether intentional or not, often unilateral, again, whether intentional or not, and whether that's the end goal or not, what are the ways to lay over that some form of coordination? And then related question, if we're talking about coordination, what should that coordination look like, right? How much of a hard law approach do we want there? How much of a soft law approach? What's the right balance there for each area of regulatory behavior? So maybe Chenyi, if you want to start with that, and then we can have reactions from others in the panel as well.
Is it working? Yeah. Okay. Thank you for the question. I would say maybe soft law approach, over more advantages over hard law in terms of greater flexibility regarding policy alternatives. So let me follow up the comment made by Martina about the data protection standard. In my view, my Chinese colleagues may disagree with me, but in my view, the concept of privacy did not exist in the traditional Chinese society. I see Henry's face, and there's no equivalent term of privacy in the traditional Chinese language. Okay, so if you think about the Confucius saying or the traditional Chinese architecture, I don't think we have privacy within the family. Anyway, my point is that so global governance on privacy or data protection become extremely complicated. If you think about how people from different cultural backgrounds define the boundary of their personal space, how people from different society value the need for privacy, okay? So the reality is that privacy law differ considerably, and the data protection regime vary considerably, dramatically actually, from country to country, from region to region. However, now we have a GDPR, and as just mentioned, GDPR, in my view, is essentially about imposing the privacy standard of one region, one country to another, because the EU actually has the power to decide whether a country outside the EU provides the adequate level of data protection. So I don't know. So I think here maybe to respond to the question, I think the APEC, the Asian Pacific Economic Cooperation, the APEC model can serve as an interesting, case for how data protection can be harmonized or cooperated through the soft law approach, because the softness of the framework actually can provide a way to avoid the ratification problems that is required for the traditional hard law treaty. And therefore, the control of the negotiation process lies more within the domain of the executive branch, as well as the experts, government officials in the area, rather than the over-politicized legislators. So that would increase the possibility for meaningful plan of actions on the negotiation table.
Thank you. And Chris, I noticed that you're ready to respond to this issue, I think, as well. How do you feel about this?
Soft law is very interesting, and it's a term that keeps popping up. And I'd written a book called Soft Law and the Global Financial System. And I came here a couple of years ago, and the looks on most, including John Jackson, when he was alive, and we would talk about soft law, was this look of bewilderment and puzzlement that trillions of dollars in the global financial system could be managed effectively through non-binding agreements, and we would always have these conversations. I think soft law, can under certain circumstances be harder than hard law. It just depends on what kinds of disciplines are backing up the soft law system. Soft law only has to do with the degree of legal obligation. It doesn't necessarily have to do with what kinds of disciplines may be leveraged in order to increase the compliance pool of any particular agreement. So you can have market pressures, right? Like if you're not complying with the Basel Accord and everybody thinks that you are undercapitalized, no one's going to want you to be their counterparty, right? Like there are kinds of ways in which you can lever sort of your reputation in markets in ways that lend teeth to even informal agreements. So the question is, or what we're seeing, I think, on the panel is this pattern where you see more of two kinds of things. You see less multilateralism, more soft law, more unilateralism, right? So now you have to ask yourself, well, what's the difference between soft law and unilateralism? They're not necessarily mutually exclusive, but they do sometimes respond to different kinds of challenges. So one reason that you actually see a lot of international financial regulatory types suddenly doing soft law, or excuse me, FinTech, isn't because we've just given up international questions, but the issue area of technology is one that, and regulating technology requires a very similar skill set and toolbox that you would normally need in the international financial regulatory space. That is, when you have technology and the speed of innovation that you're dealing with, you have to have a flexible scheme because literally different kinds of software, execution devices, digital platforms can literally change in a matter of milliseconds. You need like a PhD to be able to keep on track and to understand the speed of innovation in certain kinds of sectors. So creating some kind of framework when there are lots of open questions, when you don't really know where things are going, kind of necessitates, and I want to emphasize that because it's not necessarily a political judgment sometimes as much as it is one of pragmatism, a certain kind of toolbox in which you say to yourself, I'm either going to get information so I can later engage in the very onerous and time-consuming and sometimes politically consuming process of formal legal making, lawmaking, and then you create this framework, but you can back it up with certain kinds of mechanisms that can be deployed in a somewhat ad hoc manner, but one where when certain events reach a certain kind of point, you can lever them in order to incentivize certain kinds of behaviors. That's a soft law kind of way. When you get back to the question of unilateralism, well, why do you use unilateralism? Well, you can take it from a standpoint of externalizing your own norms and preferences. Certainly wouldn't be the first time in the world. But when you get to regulatory questions, what you tend to see is the deployment of unilateralism. Now, in a world of populism, all kinds of weird things happen, but you tend to look at extraterritoriality, as was mentioned earlier, as a means of enforcing and preserving your own domestic sovereignty. In other words, without extraterritoriality, you wouldn't be able to necessarily enforce your own domestic rules and regulations. So you kind of have to tell the rest of the world or to set a certain kind of standard in order to be able to enforce certain kinds of things that you want to happen within your domestic system. But notice that that's a different kind of game theoretic problem than you're going to have if, on the other hand, you have a kind of transnational problem in which people have varying preferences in terms of how you solve a problem that is more or less universally observed to be, or largely observed to be, a problem, like financial instability or financial market regulation. So, it's good to disentangle all of these when you're looking and look at a kind of facts and circumstances way to sort of interpret properly why different kinds of tools are being used in different kinds of contexts and which ones are going to be optimal given whatever issue area or industry scenario that we as legal practitioners find.
So I see a few of the other panelists want to respond to this, but maybe you can do it relatively briefly so we can then turn to the room. Do you want to start, Heng? Yeah?
I just have a quick one. I think it's been soft law is great, But I think it's in trade war context, it's very hard to use. Because on one hand, we need trade law or soft law because it's a new issue, soft law help to find the solution. But President Trump likes enforcement. That's understandable because you want the rule to be enforced. So there's a tension there. I think it's been in trade war context, we have a much higher demands, but much less rule tools. And better option will be under a multilateralism, because for bilateral one, you don't want to be criticized being soft. So you want multilateralism to be a good place, but unfortunately, WTO is in crisis. So another option will be go to the FTA to do soft law, but then you have problems whether they want to deal with new issues and whether it will bring fragmentation. Thank you.
Martina, Pierre-Hugues, one of you? Yeah? Go ahead.
I mean, it can also be for the discussion, but I mean, just on your point, what is the role perhaps of the WTO in this context? I sort of touched on this in the context of competition policy, for example. And I can draw the parallel here to, for example, trade remedies, right? So it's also domestic enforcement, but you have a WTO framework. So if there is a disagreement, you also have a system in a WTO where a government can take another government to court and they can solve through the WTO dispute settlement a disagreement over a particular decision in a trade defense case. So you don't have that in for competition enforcement because there are no WTO principles on competition, but you could envisage that. So that would be sort of an additional mechanism to try to resolve these disagreements in a sort of calm and depoliticized way. And then, I mean, on the soft side, and here you would have to have sort of, hard discipline so you can enforce them. But then, of course, on the other hand, you can envisage soft cooperation among competition authorities, which exists, and that can also, of course, be very useful.
Thank you. Pierre-Hugues, any? Yeah.
So coming back to soft law and the role of unilateralism in the context of financial regulation, I think it's almost inevitable that a lot of international financial regulation, for a number of reasons, will continue to be done through the soft law process. But I think what's interesting about some of the cases that I've been looking at is that you see that this is a process in which there's a lot of inertia. And so the question often becomes one of agenda setting, right? How do we get the international soft law machine going so that it addresses certain issues for which it may have had blind spots before? And certainly, I think that benchmarks were an example of that. Outside the kind of area that you're talking about, so an area like, or to come back to blind spots of the machine, an area like FinTech, right? All of a sudden, everyone wants to do FinTech. Everyone's coming to the regulators asking, how am I going to be treated if I go into this line of business? Then the regulators know that they have an issue, a common issue to deal with, and there's an impetus that's given to soft law creation by that. When there's something like the financial crisis happens, there's a huge impetus to create new rules and to coordinate them to some extent at the international level. But there are also some things that are off the radar screen that can be brought to the radar screen by enforcement and often by unilateral action. I think, as I said, benchmark reforms are a good example of that, where this kind of manipulation that had been going on for a long time was really completely off the regulator's radar screen before the Barclays case came out, which was a result of investigation by enforcement authorities, by DOJ, the CFTC, and so on. And that led to this being put on the agenda, there being creation of international standards on benchmarks that are now being implemented to many of those. And I think really one of the most fascinating cases is the tax case, where the OECD was the main forum for a long time, doing this mostly through what one could call soft law, although there were also efforts to put in place binding instruments, some multilateral, some models for bilateral cooperation and information sharing agreements. And that was going very slowly. That faced a lot of resistance from jurisdictions that did not want to share information. So there was really a deadlock in policy making at the international level. And what's fascinating about that is that after the UBS case, after Switzerland agrees to release these names, you see a lot of that deadlock unraveling. leading to the possibility, so Switzerland releases these names, then after they've released the names, it becomes almost inevitable for them to agree to FATCA. Once they've agreed to FATCA, then the other OFCs within the OECD are in a much worse position to try to resist information sharing, and just a few years after, you end up with the Common Reporting Standard, with this new standard for automatic exchange of information worldwide, which would have been a complete pipe dream 10 years ago. So I think unilateralism may sometimes be part of the answer to the question, how do you get the international rule-making machinery going and people to participate in it?
Thank you very much. So we'll turn to questions from the room. I saw one here already, one in the back there, and one here. So we'll take these three first, and then we can answer those and see if we have time for more. And please, even if you've done so already, please reintroduce yourself to everyone, including the cameras or the audio.
I'm James Flett. I work in the European Commission Legal Service. My question for the panel is about the concept of trade restriction and whether or not it is an apt tool for the purposes of the kinds of issues that you're discussing. And I ask that question because when I think about classic WTO goods law, I think about regulatory autonomy, regulatory diversity, coexistence, and the necessity test, which tells us how to coexist. And at the heart of that, central to everything, is a concept of trade restrictiveness, which even today is a bit fuzzy. We're still working out what that means, but it's got something to do with volume and price and value crossing international frontiers. But this is central to everything, and it's central to the whole regulatory system and the way we deal with it. But when I listen to these panelists, I sort of have the impression that as a concept, trade restrictiveness doesn't do it for you. It may in fact be useless. And so I don't know what will do it for you, but my question to you is, do you eliminate trade restrictiveness as a concept that can help you to solve your issues?
Thank you. So maybe we go back there. You already have a microphone, right? Perfect.
Hello. Hello? Hello? Thank you so much. Thanks to the organizers. I feel like I'm a broken record in some of these discussions because I always try to interject the views of countries that are not really represented in some of these fora, in the sense of regulatory cooperation and regulatory supervision for smaller countries has become increasingly an NTM. And what does that mean? It means that I'm from a region that is a taker of standards. And I know, Martina, the way in which you describe the GDPR and some of the standards that the EU is unilaterally, in my mind, promoting is really, it's something for my region, not just in the area of data protection, but in areas such as financial standards, is not a discussion. It's something that we need to take on board because there are consequences, for instance, of not accepting certain standards and not trying to find a way to use it as a model in our own domestic legislation, because there'll be consequences. And that happens in financial standards, that happens in data protection. We are also a region that is increasingly courting support and investment from China. So China's model, the Belt and Road, now becomes a new avenue for regulatory cooperation. Without a WTO, and I'm still not sure that a WTO is the best forum, precisely because the prism through which you look at regulatory cooperation, etc., is in the context of a trade restrictiveness sort of a mindset. And I agree with James that we need to think about whether there's a role still to be played by the initial rules that frame the WTO and the trading context, and whether it's really the best place for setting governance standards in these new areas like e-commerce and data privacy. I think emerging from this panel is the very clear view that maybe the WTO is not built to deal with some of these regulatory issues. And I guess my question after this long statement is, for the countries that really have to accept these standards in order to play in the new paradigm and to not increase the digital divide, because they want to participate and be part of the regulatory rules, where is it that we are going to help in the formulation of the standards that will inevitably affect us? And I hear that soft law is being bandied about as a potential area. Soft law obviously has its advantages, but without the rule-making sort of imperatives that we have traditionally looked to the WTO for, and the bindingness of decision-making there, and the WTO dispute settlement body, soft law is going to just mean increasing the digital divide, because those that can go ahead and use soft law instruments will do so, and those that can't really keep up and have an interest in having these rules actually enforced once they are part of it, will have no undergirding legal framework with which to enforce these rules, because it's soft law.
I'm just going to, yeah.
I'll stop.
Yeah.
But I'm saying I'm not hearing a solution. Maybe there's none. But it's really, let's bring into this the countries that cannot participate in some of these and really have the biggest interest in being part of the rule-making in these regulatory supervisory discussions. Thank you.
Thank you very much. And then we'll take one more. Yeah. Okay, well, perfect. So let's start with these two questions then. Who feels like they want to go first? Chris, yes.
I have a number of thoughts. Number one, I think that when you look at the soft law organizations, they're almost inevitably run by consensus. And as a result, to the extent to which you have smaller states and governments who are participating, that does provide avenues for engaging in rule-making and standard setting. I'm not trying to defend all soft law. I think there are definitely limitations of it. But I'm not entirely convinced that hard law processes are going to necessarily be more inclusive than soft law processes. When it comes to the financial regulatory space, I think that it's critical, particularly when you think about financial technology, and this actually gets to this question of trade restrictions. Different countries sit not only at sit on different levels of development, and they have a different risk-reward matrix. Trade is very different from financial regulation. Trade starts from the assumption that, for lack of a better word, government has kind of messed up the market, and then financial regulation kind of starts from the opposite standpoint, that there's some kind of market failure that requires some kind of governmental intervention, right? So just the starting points in and of themselves can sometimes lead you to very different outcomes when trying to find what kind of institutional structure is best suited for any particular problem. And when you superimpose that with the question of inclusiveness of that particular regulatory or standard-setting body, you end up with outcomes that are as much reflecting different kinds of preferences between the state and the economy and the market and the economy, but it's also trying to figure out what kind of, again, toolbox or DNA and efficiency in rulemaking and standard standing and in response mechanisms that's going to be required as a particular situation or issue area evolves.
Thank you. Heng?
So I think it's been respond a little bit to the BRI one. I think you mentioned about the BRI as a possible venue for regulatory cooperation. I think it's been the new emerging order means that actually we have a different options, but also a lot of challenges. But I think regardless what of the venues we choose, I think it's pretty important to establish a rule-based systems, because I think that's been pretty important for the predictability and also the consistency of the system. And also I think in setting the rules will be pretty important also to highlight the good governance, to drive down the course of that. So in that regard, I think the inclusiveness of the regulatory cooperation will be useful, because when you look back at the crisis of the current stage, one of the problems we faced in the past is that they being not as inclusive as should be. For example, trade liberalization has a negative effect certain sectors, and also in the past people may say, okay, it's a Quad who deal with the GATT rules and so on and so forth. I think we probably need to learn the lessons from that, regardless within or outside BRI, how to deal with the legitimacy issue, and how to make sure that you make rule or cooperation which deal with the fundamental underlying problems within that, and to make sure that the rule or the cooperation made sustainable. Because the current crisis indicates that even if you have a rule, they may not be sustainable. It's only probably the start of a new wave of the challenges.
And just to pick up on that, I think that when people talk about rules, you should ask yourself, what's the decision rules? Like, how hard is it to change a system, or if it's really hard, do you end up with some kind of inertia, right? And those decision rules are almost administrative state questions. And as much as you'd like to innovate in terms of the rulemaking, I think it's also important to innovate on literally how do you get to changes and response mechanisms to new cross-border legal challenges.
If anyone else on the panel who wants to react to that, or shall we? Yeah, you want to actually take that if you wouldn't mind. Yeah. Thank you. There you go. Yeah.
On the question of trade restrictiveness, I don't know if that gets to the question you were asking, but I think one thing that is notable about the kinds of enforcement actions that I'm thinking about is that they take place completely, they're unlike the kind of unilateralism that is making headlines these days, that is arguably and sometimes patently inconsistent with existing multilateral rules on trade, insofar as the kind of unilateralism that I'm referring to is almost entirely outside, legally speaking, the disciplines of the WTO and other multilateral treaty bodies. You could argue that restrictions on access to the US market, for example, prima facie could run into some problems with the GATS, but it seems to be the case that some combination of national security exceptions, the very broad prudential exception to the GATS, and perhaps the question, as Shinyi has noted, that whether any of this stuff counts as a measure of general application, if that were to be the basis for the challenge. All of this seems to have discouraged any kind of challenge to the kinds of unilateral practices that I'm referring to under existing trade instruments. So the trade-offs are a little bit different. In the trade space, you may have to trade off think about the trade-offs of whatever benefits will come from unilateral action against the risks of clearly undermining the existing system. Whereas in my field, we're talking about potentially certain benefits and also potentially certain drawbacks, but the drawbacks don't include undermining existing trade rules because they don't apply, or at least plausibly don't apply to any of this.
Shinyi? Yeah, go ahead.
Very briefly, I think this panel tried to point out that in many situations, the administration of the regulation is much more important than the regulation itself. Okay, so about the trade restrictiveness, yes, it's about the necessity test. It's actually governed by Article 6.4. However, we are talking about the administration of the regulation, and it's only required that it should be done in a objective, reasonable, and impartial manner. So it's a light application. I mean, compared with other advanced standard like necessity, proportionality, it's a very light, relatively light application. And it's also noting that there's a apparent hesitation for the WTO panels, and in some cases, the appellate body in fighting the violation of Article 10 of the GATT. In some cases, the panel state that the dispute settlement mechanism of the WTO is not intended to function as a mechanism to test the members' particular ruling, I mean the consistency of the members' ruling with the members' own law or regulation, because it is a function reserved for the members' internal, domestic judicial system. So this kind of statement demonstrates the inherent sensitivity for the WTO, to intervene with members' sovereign right.
Thank you. Let's see if we have one final question. Maybe I see somebody up there, and I saw you there. And I think, do we have another 5 minutes roughly? And then I see one question here. So if you can keep your questions relatively short, and we'll try to keep the answers relatively short as well.
Yes, good afternoon. Good afternoon, Derek Destokalper from the Analytics think tank. First of all, thank you very much. One really comment that came to me actually over the afternoon is the concept of trust, the breakdown of trust. So I was wondering actually, how would you infuse trust back into the institutions? And maybe a specific question to Christopher about DLTs and the fact that now we have actually a digital space which is actually open, some kind of a global common. Actually, do nation states alone are the key actors actually to sustain trust in that space? Or is there an opportunity for the private sector, NGOs, maybe some kind of decentralized type of governance to emerge maybe in the next couple of years? Thank you.
Thank you. And I saw a question here in front. Actually, if you're coming down there, maybe we'll take this one first, and then we'll take you.
Thank you.
Should be
Thank
on.
you. My name is Hong Liu Gong. I'm from the China University of the International Business and Economics. Just a very quick comment, no any question. So no need to exaggerate the role of Belt and Road Initiative. I think the Chinese government itself has gone through a struggle by itself in terms of a conceptual, the conceptual struggle, I would say it this way. Regionally, it is just nothing more than a development strategy, aggressive approach, proposed by China. And then China realized that it can take it maybe as an international initiative in parallel to any other global, regional, or even national framework or initiative. For instance, I just returned from Moscow, and they have something called, I just learned about that, like Eurasia partnership. And ASEAN have a lot of initiative. I think a lot of countries have their own initiative. China has their own as well. So rather than China emphasize many times, we're not trying to create any new model of global governance. We just want to maybe put some impeders to any current existing vehicle or mechanism. So, and I think there's a problem, something like, I think currently major focus of the Western world would be debt trap and diplomacy. And China realized that, and then they tried to create something called a sustainability framework and fix the problem. And eventually, maybe we would consider some other things like the sustainable development, and these kind of a final goal we want to reach as any other concern about. So in the interest of time, just to stop here. So yeah, thank you.
Thank you very much. And then we have two more. Okay, this one, and then one here on the third row.
Can I start?
Yeah, please. Yeah.
No, it's just, it occurs to me in the discussion now about access to the services market, the question to what extent come BITs into play. The US has signed about 40 investment treaties that provide for national treatment, even on a pre-establishment basis, and possibly these treaties, I have not looked in detail at them, could be as powerful as what currently exists under the GATS. And is multilateralized due to the absence of an MFN exemptions under the GATS for investment treaties in case of the US, for example.
Great, thank you. And then one last one here in the front. Perfect.
Thank you. It's a question for Heng Wang. I'm Henrique Moraes. I'm with the Mission of Brazil in Brussels. This discussion on soft law reminds me enormously of work that was led by Joost some years ago on informal international lawmaking. And I see that it's still very vibrant. But one of the criticisms that could be leveled against the shift towards informal lawmaking was that accountability mechanisms like transparency could possibly aggravate power asymmetries. And I think this is something that Pierre Hugues addressed in his article on transgovernmental networks some years ago. Now, going to Heng Wang's point, I think a point that starts to emerge in the literature on the BRI is this informal or flexible approach or soft law approach that China is deploying in its interactions with its BRI partners, so the MOUs. And my question to you is, I see the point that you make in your GL piece on how this affords flexibility to engage in trial and error. But do you think that in any extent the, let's say, informality of this Chinese approach also aggravates power symmetries as China negotiates its, let's say, increased footprint along the BRI route?
Great. So turning it back over to the panel, who wants to start? Hang, do you want to start with the last question? Yeah. Yeah. Go ahead.
I think it's being with the increased number of soft law instruments. I think it's being we'll see that how international extra-regional governance will go in the future. So that's also probably have to be depends on what the rules MOU look like, and also what are the areas they're dealing with the issues. So currently they have focused a lot on dispute settlements. China understands that, also about trade and investment facilitation. They may expand to others. Recently, they're also talking about anti-corruption. So probably have to be observed on case-by-case one, but we can chat further after that. Thank you.
Thank you. Chris.
Just on the question of trust, which is very interesting, and in a way, there's some real overlap here. Just again, just as a little footnote, I've never really thought that, or I've heard when comparing the hard and soft law systems, that even our legacy hard law systems were exactly imbued with transparency and many of the criticisms that are sometimes levied against soft law systems. But it also gets to this question of trust and how can you enhance trust in an intergovernmental context, and then can you create ultimately some kind of decentralized ledger for international economic diplomacy? And I try to explain to people when they say, okay, this is blockchain thing. So what exactly is it? And a lot of the easiest way to understand it is like an operating system. That ultimately it's an operating system, and you can throw an app on top of it, right? And sometimes that app is called a cryptocurrency. But the actual operating system, how do you make the system go? How do you do the computing? Is done not through a kind of centralized node, but is instead done in a decentralized way. So imagine if we all had one big Google Doc, and you're able to sort of make your corrections to the Google Doc or something. You're sort of powering the draft of an article forward with everybody's sort of participation. Imperfect, but gets you close enough to sort of understanding the concept behind decentralized finance, and I guess this would be DGov, decentralized governance. The concept, in order for it to work from an intergovernmental economic diplomacy standpoint, would have to involve large degrees of transparency, right? Because if you have a permissionless distributed ledger like the blockchain, everybody on the blockchain can see exactly what's happening on this ledger, because that's a prerequisite for everyone to be able to participate in this kind of operating system. How much transparency is then the optimal amount of transparency then for a synonymous or analogous approach at the international governmental level? I don't know. You would also have to be able to figure out, because there are still voting rules, and depending on if you have a cryptocurrency, how much that the way the system changes over time will in part reflect the amount of computing power that you have. So what is the computing power of international governance? When I say computer, there's a game that you have to play for, say, Bitcoin, and if you have the fastest computers, then you win the game, and therefore you have the right to memorialize a certain block of transactions, and as the block grows, you add a block on the past block, and then you get a blockchain. Well, what would that be in a DGov scenario? Is it expertise, right? Well, clearly then the less expert countries who have felt that they've been locked out since legacy systems are going to feel a challenge to that in a sense of it being unfair. But it is, all these are very interesting questions as people are trying to figure out how do you create a more decentralized environment. If soft law was one response and people are going to grumble, then what's the next best thing? And is there a network to try to operationalize some kind of new vision of governance? And so I'll use that on my exam next year for my students and blow their mind or something.
And we might want to do an entire panel on that, you know, if it's not this year, then next year maybe. I just want to make sure that we have somebody also maybe responding to the last question. Xinyi, is that something you might be able to respond to?
Yeah. Okay.
Yeah.
I think in the area of digital trade, we can see a tension between the multilateralism and multi-stakeholderism. Because the cyberspace should be governed by the multi-stakeholder approach, which means that industry-driven, bottom-up, voluntary basis. The decision making is more like inclusive or transparent. So a quick answer is that I would say government will still play an important role, but no longer dominant role.
So I'm not sure that completely got to your question. I'm not sure this is, to be honest, that this is the panel that will be able to really get to that, but maybe there's time afterwards to talk about that. I think we're also a little bit over time, but it was a fascinating discussion, I think, and I think we see from the number of questions we have and the range of questions we have that this is certainly not the end of this discussion yet. I think the organizers want to say a few words. Teresa, should I give the floor to you for a moment? Maybe just after thanking our panelists for what I think was a wonderful discussion, and thanking all of you.
Hello? Okay, so thank you. Actually, Navath, I wanted to thank you and our other valuable sponsors without whom we couldn't do this conference. So thank you, everyone. A round of applause for Aikengump, Lee & Co, Van Balen Bellis, and Wilma Hale, please. We love working with you, and long may this continue. So now a really practical announcement. The dinner, which is for the sponsors, the speakers, and other people who have signed up and registered for the dinner, will be at the L'Appel du Lac, which is about a 10-minute walk from here. So in a few minutes' time, we'll be setting off from upstairs. If you don't know the way, then please congregate just outside between the two petals upstairs. And see you there. And thank you very much for everyone who's still here at 7:30. Well done, all of you.